after hearing what really happened, contrary to what the prosecution has led you to believe, I will now leave you with one thought to consider. Is it fair to take advantage of someone because they have a disability? Is it fair to let an innocent person take the blame for a crime they did not commit? Is it fair that on December 17, 2003, Casey Turner manipulated Max into hot-wiring Miss Abuela's pink Shelby Ford Mustang in order for Casey to drive his grandmother's car, only to blame Max for a crime he did not and by far could not have committed? No. No, it is certainly not fair that when Max and Casey went to Casey's house after school, Casey did not specify exactly which keys he did not have. Above all, it is not fair that Casey Turner took advantage of Max's disability and manipulated him into configuring the car to start, only to blame it on poor, naive Max. Casey met Max through a social group set up at school to facilitate Max make friends and enhance his social skills. Although the social group was made to help Max, it also helped Casey. There, Casey noticed that Max was easily exploited by others. He also saw that Max had a way with cars. He knew them inside and out. He was also obsessed with them, in particular with his grandmother's pink Shelby Ford Mustang. The Mustang belonged to Casey's grandmother, and the car had both a very expensive price value as well as sentimental. Casey was never allowed to drive it and was often teased for never being able to drive it because it was sitting in his driveway. Casey, unlike Max, is not naive. He knew that he could easily persuade Max into hot-wiring the car and blame it on him, and that nobody would believe him. Max is not the one who wanted to drive the car. In fact, Max's parents bought him his own Mustang. Don't you think Max would want to drive his own? Casey, however, felt as though he needed to prove himself because everybody made fun of him. Casey wanted to drive the car, and Casey drove the car. To quote Casey, "It's not like Max has a scholarship to lose or anything." Yes, Max does not have a scholarship to lose, but Casey does. If truth be told, a scholarship is not only the thing he has to jeopardize, but also he was at risk for losing the car if caught by his grandmother. In fact, his mother, who was caught taking the car, was not allowed to drive it by his grandmother's orders. So in reality, Casey was the one with something to lose. When Casey took the car, he was unaware of the consequences he would be faced with until he got to the pizzeria when Logan informed him of what would be awaiting him. Right after Logan told Casey that he would lose his scholarship as well as the car, Casey got up and made his fake 911 call to 911 and to make his story more believable. When Chief Parker Carr arrived at the pizzeria, Max admitted to taking the car. However, he did not admit to in fact driving the car. When Max was arrested, he put up quite a fight. At the police station, he put up resistance, enough for 2 police officers to restrain him. Isn't that strange? Someone who admits to something so openly still puts up restraint? The reason for the resistance? Because Max did not fully comprehend what Chief Parker Carr was asking him. He did not know what he was confessing about due to his autism. Although Chief Parker Carr put a syntax error into the text and Max caught it, it does not mean that he fully comprehended what the document was actually stating. Actually, Chief Parker Carr himself said that Max might have not understood what it was saying. That is why, ladies and gentlemen of the jury, it was that we have proven Casey Turner's manipulation that led Max to rewiring the car in order to help his friend get to the pizzeria, in which Casey, by his own selfish means, drove his grandmother's car. Casey did not call home or the police in the car. Why? Because Casey was driving the car. Casey has more of a risk to lose and did not think Max would get in trouble. Because in the words of Casey Turner, special ed kids get away with everything. It would just be like when Max stole the purse. In Casey's eyes, it would all go away and Max would be fine. Casey would keep his scholarship and the car, and Casey would be able to prove himself to his friends. Ladies and gentlemen of the jury, on behalf of my co-counsels and I, we thank you for your time and openness during the case. As not only members of the jury, but human beings, will you please make the correct decision in seeing that Max is not guilty, but rather the helpless victim of the exploitation set upon by Casey Turner. Not only for Max's sake, but for the sake of justice, please. Thank you.
I was taught to take responsibility for my actions when I take things that don't belong to me. I was responsible for the Shelby being taken from Casey's grandmother's driveway. This is a confession. These are the words of the defendant. These are the words of a person who was just caught stealing a car. These are the words of Max Ability. Thank you, Your Honor, counsel, and ladies and gentlemen of the jury for listening to the evidence we have presented today. Max Ability is charged with 2 crimes: theft by unlawful taking and unauthorized use of an automobile. A person is guilty of unauthorized use of an automobile if he or she operates an automobile without the consent of the owner. A person is guilty of theft by unlawful taking if he or she takes or exercises control over movable property of another with the intent to deprive him or her thereof. We have proven, through the testimony of Casey Turner and Chief Carr, as well as through the evidence we have presented today, that Max Ability is guilty of both of these crimes. On December 17, 2003, the defendant brought wire and alligator clips to Casey Turner's house with the intent of hotwiring Casey's grandmother's car, a 1967 Shelby Ford Mustang. He did hotwire the car, and then he got in and drove away with his friend Casey in the passenger seat, trying to convince him to stop. Casey eventually did convince him to stop. At J&T's Pizzeria, where Max parked the car behind a dumpster so no one would be able to see it from the road. When they got to the pizza shop, one of their schoolmates, Logan Kay, was inside. As soon as Casey got a chance to slip away from the defendant, he went and he called the police, but he hung up when he saw Chief Carr enter the pizza shop. Max then confessed in the presence of Chief Carr and of Logan Kay to hotwiring and driving the car. He said that he wanted to continue driving and take the car for a long ride. Not only did Max verbally confess, he also gave a statement and signed it in the presence of Chief Carr. You already saw that statement today. In it, he says, "I wanted to drive that car. It is the best car in the world. I like taking that car out for a ride, and I am sorry you took me away from the car. I was looking forward to going back out in the car after we ate the pizza." Is this really the statement of someone who did not want to drive the car, as the defense has just claimed? The defendant admitted to stealing this car, and he admitted to doing so without Mrs. Abuela's permission. He also knew that Mrs. Abuela would not let anyone else drive the car. Casey's grandmother had taken the keys from Casey, so Casey wouldn't drive the car. No one could get the keys because Casey's grandmother never let anyone have the keys. The defense has tried to manipulate the facts we have presented today with the fable they have presented. That it is just that, a far-fetched fable based on the unreliable testimony of 2 biased witnesses. First, they had Dr. Jones testify, a longtime friend of the family, who doesn't want to do anything to jeopardize that relationship. You just heard her say that if an old friend asks her for something, she can't turn them down. Then you heard Logan Kay testify, who's a friend of the defendant's, and he also has gotten in trouble for stealing before, and now he's trying to get revenge on the person who turned him in by accusing that person's son, Casey Turner, of a crime that Max actually committed. The defense's story is full of contradiction and loopholes because only our true account makes sense and can logically explain the event that occurred. First, you heard the defense tell you that Casey instead of the defendant drove, but where is the evidence to prove that? No one saw him driving or even sitting in the driver's seat of the car. Next, you've heard the defense tell you that Casey is blaming Max because he doesn't want to lose his scholarship or his chance to inherit the car. But why would Casey risk these things that are so important to him for a quick joyride to the pizza shop where he was sure to get caught? You also heard the defense claim that the defendant was easily manipulated by his friend. But then you heard Dr. Jones tell you that she talked to Max before about stealing and told him that helping people to steal is always wrong. Finally, you heard them try to discredit Chief Carr by saying he's biased because of a previous incident with an Asperger's child. But you also heard Chief Carr tell you that this incident served a different purpose. He just wanted to make sure everything was done correctly in this case. The true facts are these. The defendant brought alligator clips and wires with him to Casey Turner's house with the intent of hot-wiring and stealing Mrs. Abuela's car. He did hot-wire the car, and then he stole it, and he drove it to the pizzeria, where he was caught. He then admitted to doing so, both verbally and in a signed confession. If you remember nothing else when you go into your deliberation, remember the defendant's own words. I was taught to take responsibility for my actions when I take things that don't belong to me. I was responsible for the Shelby being taken from Casey's grandmother's driveway. Today, we have clearly shown, beyond a reasonable doubt, that Max Ability is guilty of both theft by unlawful taking and unauthorized use of an automobile. And therefore, I ask you to return from your deliberations with the only verdict consistent with the facts presented, a verdict of guilty. Thank you.
All right.
Your Honor,
Yes.
if I had been permitted to object during the closing statement of the teams, I would object to the fact that Exhibit C is not a confession, but rather a statement of Max's ability. Thank you.
Okay. Okay, I guess you judges go out and do your thing, all right? I'll talk to the troops here for a minute.
Good job, you guys. Good job. Good luck.
I don't know this might be whoever judge. Okay, I have a few comments. One that if there were any other attorneys in this room who have heard me charge a jury, you're going to laugh, as the court reporters do. Try to slow down your speaking. Just a real quick sidelight. One time I finished charging a jury and I said to the court reporter, Jenny, I said, well, I did you a favor today. I slowed down my speaking rate when I was addressing the jury. She looked me straight in the eye and said, you did what? But I noticed just one or two of you got pretty close to the jury over here when you were opening, and I made a note of it. It might be all right with there four, but if you had a full jury, you can't see them all. It's better if you back off just a little bit to get a wider periphery. There are problems in this courtroom in that sometimes if you get right in the middle, your words sound like you're pounding you on top of the head when they bounce off that ceiling. So I can understand sometimes why people do get closer. Okay. Let's see what else I had. There was on one witness, Larry Kay, was on the stand. I thought the cross-examination about his record and more trouble was good. He had a crime and falsity crime, so you could bring it out, but he had it, and a redirect, therefore, was also good on that. I didn't make a note of what it was, but it picked up nicely. There's in the summations, the defense, I think, did a very good job in attempting to and emphasizing the defendant's condition, that maybe he wasn't quite as responsible as he should be for the crime. And I think that there's certainly one of the things you had to work with, and you did a nice job with it. And then on the prosecution side, in the summation, you made very clear to the jury what they were charged with, and I think you even read the elements of one of the crimes to them, and that's good. So that as long as it's not too long, and that the jury knows what they're supposed to do. Of course, in a real trial, in the charge, I would have gone over them too with it, but it doesn't hurt to steal the thunder a little bit of the judge and let them know at the time. I was just curious. It's really a minor thing, but on the first opening, you made a sentence or so before you said, "May it please the court." And I think you should say, "May it please the court" first, before you get into the opening. And maybe you had a reason for doing it to emphasize something you were saying right in the beginning. If so, it's not a mandatory rule, but customarily, it's usually "May it please the court" comes first. And I'm not sure, and we hear it done all the time, it's something that I always question when it happens in real courtrooms too. The witness has just been sworn in. They've been asked to give their name, they've been asked to spell their name for the court reporter. And the first question I think some of you asked each of the witnesses, "Would you state your name?" Well, they just did. Or state your name for the record. The court reporter is taking it down when they're sworn in. And Bob's always very good at asking their name and spell their name. So I don't know. I know lots of attorneys do it. And I don't know whether there's a rule against it or it shouldn't be done or it should be done. But it's done by many real life attorneys. First thing they ask, state your name. Well, I just gave it about 2 seconds ago. And I guess maybe it's a personal thing with me, but it grates a little bit on me. Think about it anyway. I think they're the only comments. Did you notice anything, Bob? Okay. Bob's my regular court crier. So. He's not usually bashful about telling me things, too.
I've been resting.
He's been resting. Well, he was off today, so he's in a good mood right now. He hasn't had to work all day, right?
Yeah.
Yeah, except he gets started bad every morning.
I don't have any questions. I thought they did an excellent
I
job.
do too.
And I want to thank you for taking your time also, because this means an awful lot to both teams.
I've been doing it for, I say 10 years, and Bob reminded me it's longer than that. And I just love to do it. I think the students are so good.
They are, and they're very...
Amazes me the voice they have and the ability they have, and so many times the ability to think on their feet when the witness doesn't give them the right answer or out of a script, they have a way to get around it and do it. And it's good. It's good training.
Great. Do you guys have any questions
You have
for
any
the
questions
judge?
for me?
No, I just want to thank you for your time. Yeah.
Oh.
Thank you very much.
It's my pleasure.
No questions?
No questions?
You got to be kidding me.
Which school is which? Or am I supposed to know?
We're in Norristown.
We're Norristown.
You're Norristown.
Norristown.
You're Wissahickon. Looks like somebody's panic.
Do you guys want,
actually.
do you guys want to exchange your
Oh, that's right.
your best witness and your best attorney?
They got their vote and everything? Okay. I forgot.
That's all right.
Do you guys have your sign? Yeah, hold on a second. Do you want us to give them? We'll give it. Okay,
Let the Commonwealth go first. They go first.
we have best witness to Casey Bennick. Okay. And best advocate, Isabel. Is it Leroy or is it Renee? We couldn't tell.
Leroy.
Okay. Thank you. Oh, is that me?
Good.
Oh, no, thank you. Okay, and for Best Advocate Award, we have Rebecca Alderburn. Yeah. And for the Best Witness Award, we have Hugh Nick. Took her a little bit even to get a mom's name.
I'm glad I didn't have to vote on that. They're all good. They're all good. Any other comments? Anybody? Maybe go find a jury, Bob. What's a civil case? I don't know what it is.
I won't necessarily just pronounce it. That was good. And then when you parked the car, that was at the Jackson Bank. You walked back. Yeah. So they said that you parked the car.
From the judge, my letter. I wrote a letter, so I don't get that. Anyway, if you think I'm talking here, it's ridiculous. Sounds good. Oh, here, the jury's returned. All right, members of the jury, have you agreed upon a verdict?
It's very difficult, but we have, Your Honor.
All right. Would you Tell us what your verdict was.
By a score of 65.25 to 63.25, we have found for the Commonwealth.
Comments? Do you have any comments?
I guess just at the outset, if we as trial lawyers had the time constraints on us that you folks do, we would never make it. We would never be able to meet it, and it'd be impossible. Yeah, I mean, there's just, to do a closing argument with all the things that are involved here in 6 minutes or less would be very, very difficult. But everyone really did a great job, and I'm sure you were nervous, being your first experience, to get these things done in a certain amount of time, but it was just very, very impressive. I don't know what else to say about it on both sides. And it was one of those things, as I was listening to it, I'm going back there thinking I know how the scores are going to come out, and then you add it up, and it was just very close.
Anybody else?
I think I would just say that you all have amazing presence. I mean, I think that's for all of you, even the witnesses. And I'd like to say that, you know, in high school, if I had the same kind of finesse and skills that you guys are developing now, you know, I can only imagine what kind of attorney I'd be now. So you guys are way ahead of the game, way ahead of the game.
Very nice job. Did a great job.
We have a real talkative attorney. Okay, I guess court's adjourned.
Thank you, Judge.
Right.
I can't believe you
My dad wants the whole team together.
I miss you, Anna, next year.
I am like I'm like,
Daddy, this is Phil.
My daughter's trying to use your taxi.
Yeah, I'm a taxi. I'm a free cab.
I wasn't nervous.
they go back.
Get it all out. Everybody. And the beginning I was.
Tell me what your part was here.
I'm an attorney for the defense, but I go on Wednesday. I didn't go today, so.
And I didn't touch my hair that much, did I?
I'm going on Wednesday as an attorney for the defense.
You did all the a few times. Yeah.
Oh, what? What am I doing?
She's Dr. Quincy Jones.
I'm Dr. Quincy Jones.
I am Casey Turner.
I don't know what's going on.
I'm Jacqueline Nudie. I'm a defense lawyer.
I'm Becca Alder, I'm a prosecution lawyer.
How's it feel about today's win?
And I'm Chief Public Car.
How do you guys feel about today's win?
It's great. So excited.
You did an amazing job.
How are you?
Hi.
How do you guys feel about today's
We're very happy for Norristown. We think that we did very well and we tried our hardest. So proud of her. And we're happy for Norristown. Congratulations. And we think that we did well and had personal achievements. So it's only 2 points. So next year.
Thank you.
Thanks.
I gotta go catch up with them.
You guys ready to take off?
Dad, we're going out to dinner, okay?
Your daughter did wonderful again.
Where are you going?
I had to let her in and stuff.
1, 2, 3, 4, 5, 6.
Can I come?
I only have one ticket.
Who are you going with? I said only one ticket. I'm asking who he's going with.
One ticket.
Oh, that was fun.
I'm gonna bring all your stuff.
Yeah, I did.
Yeah. I was really surprised you guys didn't want to. How do we get it? Oh, there's something from that.
I've never done anything.
Here's the camera. Back up.
That's my camera.
Okay, I need to lose.
Yeah, he
That's what he said the verdict was.
My shoes are dirty.